It depends on what your charge is, and it depends on who your judge is. So let's start with DWI second. If you are charged with DWI second, even if your first DWI was 100 years ago, you have to get an ignition interlock device by law. That is something that the magistrate judge has to order, and the county court judge that you're in front of has to uphold. So if you don't have a car, or if you're like folks that we talk to a lot who say, well, I'll just say I don't have a car. I don't have a car. Well, that's fine, but they're going to modify the conditions of your bond, and they're going to make you have a portable device that you have to blow into 4 times a day, 7 days a week, which creates a lot of opportunities to make a mistake. It's easier to put it in the car. You don't have to think about it. But let's go back to the other thing. If you're charged with a DWI first in San Antonio, it's going to depend on who your judge is if you have to have ignition interlock. Most magistrate judges are not going to order ignition interlock for a DWI first, and most county court judges are not going to add it as an additional condition of bond when your case gets to them. There are exceptions, of course, for aggravating circumstances. There are exceptions for super high BACs. There are exceptions for people who have a lot of criminal history. And then there's also an exception for County Court 12. Judge Yolanda Huff is the presiding judge in County Court 12. And of all of our judges, she is the only one that orders every defendant in her court to have ignition interlock, even if they don't have criminal history, and even if none of those aggravating factors are present.